Legal aid. Legal assistance may help to cover the costs of legal aid, family rehabilitation, and representation in a court or tribunal. It was planned to make justice open to everyone in the world, irrespective of how much they receive. The scheme guarantees the basic values of a free society, that all are equal before the law and have the right to a fair jury. Moreover, after the 1998 Human Rights Act, if an individual cannot afford legal counsel, this may weaken their right to a fair jury, a right covered under Article 6 of the Act. Legal assistance is generally required on all felony and civil situations. However, the breadth of the fields of legislation funded by and qualified for legal assistance has continued to expand through the decades. Both people, once they are detained and brought to a police station, are entitled to free legal counsel. Nevertheless, whether they are taken to a judge or a criminal lawsuit, it will be decided that the person is entitled to legal help. For this reason, a person must follow certain financial requirements. Only the disposable income and the discretionary capital of a household will be measured if the income of their partners is not included. When a person falls below the financial level, they would be entitled to legal assistance. The criterion for eligibility has modified over time and therefore relies on the degree of the case. At present, if an individual's profit, earnings before tax, are higher than £2,435 in the last month, or if you have higher than £8,000 in discretionary resources, they would not be qualified. While the requirement for legal assistance has increased the bulk since the overhaul of the laws, the sort of situations allows one to legal help. The next article goes on with the history of legal assistance and from what it actually offers. Before 1900, legal assistance to anyone who could not afford a lawyer had only come in the form of voluntary contributions, which were unreliable and contradictory, leaving many individuals without legal defense. In 1926, one of the pioneers of these humanitarian organizations stated that such a structure made the rule of law anemic, attenuated make-believe that we perceive as fairness in the eyes of the weak. However, during and after World War II, attention was given to creating a fairer community. A welfare scheme was developed and implemented by the National Social Protection Agency, NSA, and, under the Legal Advice and Assistance Act of 1949, a new centralized program of legal aid was first created. The revolutionary framework accepted that freedom of entry and the right of justice before the law was essential to a fair society. Divorce in the High Court was the first goal of the program, and, by 1950, it presented 80% of the community with an established right to legal assistance. Legal assistance has grown dramatically over the decades to come. Community legal assistance was introduced in the 1960s, and in 1980 for the police and community proof legislation allowed for service support systems in police stations. Law clinics have since been opened, and legal assistance for housing and job situations has also been steadily expanded. However, as the program of legal assistance expanded rapidly, the controversy around it developed more and more and was dominated by its cost. Legal assistance has been largely accessible even to people whose compensation is at the lowest point. The next significant overhaul of the legal assistance program occurred in 1999 when the Access to Justice Act was enacted. The act was intended to reshape the whole structure of finance and the oversight of legal assistance in order to sustain a program that has changed dramatically since its creation. The act created the Legal Services Commission and granted it the authority to reshape legal services. That influence was strengthened in 2006 when a new ministerial position was created to overhaul legal aid. The act provided for legal assistance if one was financially eligible, in all criminal proceedings and in all civil litigation, except those expressly omitted. Given its attempts, the law was not adequate to regulate the cost of legal assistance. Cuts to legal aid also been an issue and a subject of national discussion and change. Since 2009 there have been 60 years of legal assistance in the United Kingdom following the Legal Advice and Aid Act of 1949. While, in particular, 60 years since the inception of legal assistance, 83% of the general population claim they have little to no understanding of the program, according to a recent analysis. Indeed, the shift of access to justice after 1949 has been evident. However, 2013 saw yet another move contributing to more cuts in legal assistance. The legislation on legal assistance, sentencing, and punishment of offenders 2012 aimed to decrease the budget for £2 billion of compulsory legal assistance in England and Wales by £350 million a year. This reverses the situation that legal assistance had been essential for all criminal proceedings, excluding those expressly covered by the 1999 Access to Justice Act. The Act absolutely eliminated support for all aspects of civil law. It includes civil and social protection and serious injuries. A strong example of recourse to justice can be made in a divorce. One of the most commonly exploited fields of law for legal assistance since 1949 is still totally exempt under the 2012 Act. Others, such as debt, housing, and welfare problems, and citizenship is only liable even if they follow those requirements. As the preparations for the 65th anniversary of legal aid were limited, although the anniversary would be a moment of joy, 600,000 individuals have lost access to civil legal aid as a consequence of changes enacted by the government in April of last year. Today, the United Kingdom's legal aid program is under intense review as a consequence of ongoing expenditure reductions. Law Society, representing, encouraging, and helping attorneys, publicizing their special role in offering legal counsel, securing fairness for everyone, and maintaining the rule of law, addressed their questions in their general election briefs this year. The Law Society is aware that changes in trial costs, trial delays and reductions in legal aid are slowly eroding access to justice for common citizens in England and Wales, weakening their opportunity to practice their freedoms. The president of the Law Society, Robert Bournes, indicated that the disaster of the Grenfell Tower was to some degree triggered by reductions in legal aid that might have taken place. As one examines the history of legal aid and its growth to date, it is impossible to overlook the reality that change seems to be linear and reverts back to 1949. As the Bot and CO Enforcement Squad. Solicitors comment, the weakest of society are likely to fail to obtain legal help as individuals may not be willing to afford legal services. This addresses the idea that a program intended to help those who use it desperately is the very structure that will actually prohibit certain individuals from getting access to legal security. Individuals that now and again have to focus on charity and NGO support to obtain the legal help they require. These are the only possible questions that can be asked in the paper. Ensure that you do not leave the appeals, ADR and legal aid since they are tested the most. Do not try attempting this question if you are not sure that you know all the above-mentioned concepts. Commentary in this question would be much less since there is a lot of material that you will be assessed upon. Moreover, make sure you answer this question strategically as it has a lot of steps and some steps have loopholes like the leapfrog appeal. Make a mind map if you wish to attempt this question. Get complete notes in PDF and book form from our Amazon store. Link given in description.